Hello, everyone. I hope you're doing well. Today, I'm going to talk to you about insurance bad faith. So, you've heard me talk before about first party bad faith, but this is going to be about third party bad faith. And as always, this is a pretty complicated, in depth topic, so I'm just going to barely skim the surface of it for you guys so you at least have an idea what it is. So essentially, bad faith on behalf of an insurance company and a third party claim occurs when your client is essentially clearly injured and there's clearly damages in the case, and you make a demand to the insurance company of the negligent driver, so the person who hit you, for the insurance policy limits. If the insurance company was given enough information and enough time to evaluate and factors like that, and they reject your demand for just some crazy reason or for no reason at all, you can then possibly what's called open the insurance policy. And essentially what that means is if a policy is opened, then the amount that you can recover is astronomical. So, everyone who purchases insurance has liability limits. So the minimum limits in Missouri are 25,000, 50,000. It can go 100, 300, 250, 500, 500, 500. So essentially, insurance companies are supposed to reasonably settle claims within the insurance policy limits so as to protect their insureds from excess verdicts at trial. Because if someone only has $25,000 of limits and you go to trial and get just for example, $100,000 verdict, essentially that insured is on the hook for that additional $75,000. That's the idea of it, is that we put the insurance companies in a position to say, hey, it's your duty, you have ethical duties to protect your insured from excess verdicts like this, and we are giving you the opportunity to settle within these limits. So that may seem kind of easy to do, but it's not. It's not something that can happen with every single case, and it shouldn't happen with every single case. But when you have someone who is clearly injured and their damages exceed the policy limits, the insurance company should tender those. They should not make you have to negotiate with them, and then make you file a lawsuit. Because if they do, then their insured is on the hook, and then that gets the insured mad. So if there is a verdict against the insured, it is then that the attorney, like myself, the plaintiff's attorney, teams up with the defendant, who was the insured, and then we go ahead and sue the insurance company for bad faith. So kind of complicated because the defendant has to be on your side at the end. But I mean, if my insurance company didn't protect me when they were supposed to and easily could have and settled for the limits that I pay for, then let's get them. So that is the gist of insurance third-party bad faith.